Imagine this. It's early morning, barely past sunrise. The country is just waking up. Newsrooms are quiet, and court watchers are expecting another slow, procedural day until suddenly a notification explodes across the legal world. A Supreme Court ruling has dropped. Not a scheduled decision, not a previously announced ruling, not anything on the public calendar, just a sudden, sharp emergency-level action that lands like a shockwave on every desk from Washington, D.C. to the smallest gun shop in rural America. And this was not the only blast, because at the exact same moment, almost like someone flipped a switch, inside the Department of Justice, the DOJ quietly released a revised, completely altered legal position, one that immediately threw gasoline on the already burning fight over suppressors, NFA restrictions, and the very boundaries of federal firearm authority. And if you think this was coincidence, think again. Nothing in federal law, especially in the DOJ and Supreme Court pipeline, ever happens without a chain reaction of internal events. This was intentional, this was strategic, and this was decisive. Something shifted behind the scenes, something big enough that the court felt compelled to respond instantly. And now the entire country is trying to understand how one sudden ruling and one stunning DOJ reversal managed to flip the entire suppressor debate upside down in a single day. Because here's what makes this moment different from every previous to a battle. For the first time in years, the federal government's own legal arguments are collapsing from the inside. For years, decades actually, the DOJ insisted suppressors were dangerous, tightly controlled, essential to regulate, necessary for safety and crime prevention. They repeated that narrative in court after court, brief after brief, hearing after hearing, but then, with no warning, they backed off. They softened their argument, they withdrew key claims, and they signaled a change in enforcement posture that instantly weakened the legal foundation of the NFA suppressor provisions. The DOJ never does that. Not unless they're forced, not unless something huge is coming, not unless they know they're about to lose. And that's exactly why the Supreme Court's sudden action matters so much. They weren't reacting to a routine filing. They were responding to instability caused by the DOJ itself. If the federal government can't defend the NFA with a consistent argument, the entire legal structure of suppressor regulations becomes exposed, vulnerable, fragile, and that's when the court steps in. The court hates uncertainty. Lower courts hate confusion. States hate unclear federal power. A sudden DOJ reversal creates all three. And as soon as that reversal hit the docket, legal analysts said the same thing. The Supreme Court is about to get involved. Hours later, that prediction became reality. But the magnitude of the ruling wasn't fully understood until the reaction started pouring in. Gun owners flooded forums, social media, and legal channels with shock. Attorneys who had been fighting NFA cases for years went on live streams trying to interpret the implications. State governments held sudden emergency discussions, and anti-gun groups immediately started firing off statements accusing the court of destabilizing national safety, even though suppressors are used in less than 0.003% of crimes, according to the FBI. But the real panic wasn't from activists. It was from state attorneys general. Multiple states publicly said they will continue enforcing suppressor restrictions regardless of federal uncertainty. Others said they are pausing enforcement pending legal review, and a few states, especially those facing active suppressor lawsuits, began quietly preparing for the possibility that their laws may be struck down altogether. Think about that. Some states are preparing for suppressors to become legal. Not in 10 years, not in 5, soon. And that wouldn't be happening without the Supreme Court's intervention. Here's why the ruling matters more than people realize. The court didn't simply respond. They stepped into the case, into the chaos, into the conflict. That means they're not done. That means they didn't drop a ruling and walk away. That means they are watching this situation closely, waiting for the next filing, the next inconsistency, the next overreach, the next opportunity to strike. This is exactly how the court starts dismantling a federal overreach. Step 1, identify the instability. Step 2, insert the court into the process. Step 3, wait for the government to contradict itself again. Step 4, issue a ruling that forever changes the law. We are already through the first two steps. Now here's the part almost nobody in mainstream media is talking about. The DOJ's reversal did something disastrous to their credibility. They broke the consistency of their own legal narrative. They said one thing for decades. Now they're saying something else. That alone gives the court grounds to question the legitimacy of their claims. And when the court starts questioning, the NFA starts trembling. The NFA is not legally invincible. It is not historically justified. It is not constitutionally supported under the Bruin test. In fact, under Bruin, the NFA is in deep trouble because Bruin requires historical tradition to support modern gun laws. There is no historical tradition restricting suppressors. None. The Founding Fathers didn't ban sound-dampening devices. Early America didn't regulate firearm accessories. Suppressors didn't become regulated until 1934, and that was based on Prohibition-era panic, not constitutional reasoning. So when the Supreme Court looks at the NFA through the lens of Bruin, the argument collapses, and the DOJ's sudden reversal makes it collapse even faster. Now let's talk about the nationwide pushback, because this is where the real battle is erupting. Within minutes of the ruling, anti-gun organizations launched campaigns declaring the court was endangering the public. They used fear-driven messaging. They told people that suppressors will become common on every street corner. They claimed criminals will now operate silently. None of this is supported by data, but fear is their tool. But at the same time, 2A groups went on offense. They said this is the biggest breakthrough since Bruin. They said the court is finally targeting the NFA. They said gun owners should prepare for major changes. They said the DOJ's reversal is proof the government knows suppressor restrictions won't survive in court. And honestly, they're not wrong. You can feel it. You can see it. You can sense the momentum shifting. For the first time in decades, the fight over suppressors is not being treated like a fringe issue. It's being treated like a constitutional crisis. Let's talk about the gun owners themselves, the people actually living under these laws. For years, they've been forced through a humiliating marathon of fingerprinting, background checks, months-long waiting periods, $200 taxes, and endless government delays just to own a simple safety device. And for years, they have asked the same question. Why is this regulated like a machine gun? No one has had an answer. Now, suddenly, the Supreme Court is stepping into the conversation. This is validation. This is momentum. This is the first crack in the foundation of the NFA suppressor system. But the biggest question right now is this. Did the DOJ's reversal accidentally accelerate the collapse of their own regulatory power? Because if the DOJ wanted to strengthen their position, they did the opposite. If the DOJ wanted to stabilize the case, they shattered it. If the DOJ wanted to keep suppressor regulations safe, they exposed them. And the Supreme Court saw that weakness instantly. That's why today feels historic, not dramatic, not overblown, historic. This is the kind of moment future legal textbooks will mention. This is the kind of moment that reshapes federal authority. This is the kind of moment that signals a shift in constitutional interpretation. And the ripple effect is only beginning. By the time this legal battle ends, weeks, months, or years from now, the NFA may look completely different. Suppressor ownership may be easier, faster, cheaper, or completely deregulated. And the Supreme Court's involvement today will be seen as the first domino that started the entire chain reaction. So, the final question stands, did the DOJ just handgun owners the biggest constitutional opening in suppressor history? Because all the signals, all the timing, all the reactions, all the legal shifts say one thing. Yes, they did. And now the Supreme Court is aiming directly at the NFA.